Did you know there's a way in Texas to pass your home to your loved ones without going through the long, expensive probate process? The trick is choosing the right deed, but the difference between the options can really affect your family later on. Today, I'm going to break down the difference between a ladybird deed and a transfer on death deed and what each one could mean for you. I'm Jennifer Nichols with J. Nichols Law. If you own property in Texas, understanding how these two types of deeds work and which one fits your situation can save your family time, money, and stress. Let's start with the basics. A transfer on death deed is a statutory deed authorized under Texas Estates Code Chapter 114. This allows a property owner to name one or more beneficiaries to automatically receive ownership of real estate upon the owner's death without going through probate. The key requirements are that the transfer on death deed must be in writing and meet all the formalities of a recordable deed, state that the transfer to the beneficiary occurs at the owner's death, and be recorded in the county's deed records before the owner's death. While alive, the property owner retains full rights, including the right to sell, mortgage, or revoke the transfer on death deed at any time. The beneficiary has no rights or interest in the property during the owner's life. The property passes automatically outside of probate and with a step-up in basis, but is subject to liens and a 2-year period, allowing creditors to access the property if the estate is insolvent. A ladybird deed, also called an enhanced life estate deed, or sometimes a warranty deed with reservation of enhanced life estate, is a Texas common law instrument. With a ladybird deed, the property owner transfers a remainder interest to a beneficiary but retains an enhanced life estate. The deed gives the owner broad powers to sell, mortgage, lease, or otherwise deal with the property without beneficiary consent, and revoke or change the deed at any time during life. Upon the owner's death, the property passes directly to the remainderment, bypassing probate and with a step-up in basis for tax purposes. Transfer on death deeds and ladybird deeds are similar in that they both transfer property outside of probate and are revocable during life. For those receiving Medicaid long-term benefits, they both protect your house from recovery by the Medicaid Estate Recovery Program, known as MERP. Finally, property conveyed under either deed will receive a step-up in basis upon the death of the grantor. This means that the grantee or beneficiary won't have to pay a capital gains tax on the appreciation of the property through the grantor's time of death. Now, let's talk about the differences. Property passing by transfer on death deed is subject to a 2-year period, allowing creditors to access the property if the estate is insolvent. Title companies are often reluctant to ensure title to property passing by transfer on death deed until the 2-year creditor claims period has expired. Ladybird deeds have no such 2-year clawback period, and therefore title companies will typically ensure title passing by ladybird deeds without waiting a 2-year period. Another difference is that property passing by transfer on death deed to more than one grantee must pass in equal shares. Ladybird deeds can pass to grantees in different percentages. For example, with the ladybird deed, you can leave one grantee a 60% interest in the property and another grantee a 40% interest. Also, transfer on death deeds must be executed by the grantor directly. An agent under statutory durable power of attorney is not authorized to execute a transfer on death deed on behalf of the principal. A ladybird deed, on the other hand, may be executed by an agent under a statutory durable power of attorney if the power of attorney authorizes it. If the agent under power of attorney executes a ladybird deed in favor of themselves as grantee, the power of attorney must contain self-dealing provisions allowing gifts to be made to the agent. Another difference is that if the property has a mortgage, a transfer on death deed will not trigger a due on sale clause. A ladybird deed might trigger a due on sale clause, meaning the mortgage could be called in. However, As long as the mortgage is being paid, you shouldn't have a problem, even with a ladybird deed. Finally, transfer on death deeds can name a contingent grantee to take in the event that the primary grantee predeceases the grantor. There is no statutory authority allowing a ladybird deed to name contingent grantees. If you have a ladybird deed and a grantee predeceases you, the best practice is to revoke your ladybird deed and execute another one in favor of the new beneficiary or beneficiaries. So, which one is right for you? It really depends on your situation and your objectives. If you're worried about protecting your property from creditors, or your grantees might want to sell the property after your death without waiting 2 years, a ladybird deed is the safer choice. If you want to leave property to grantees in different percentages, you should go with a ladybird deed. If you are an agent of the grantor under a statutory durable power of attorney and the power of attorney allows it, you should go with the ladybird deed. If none of these situations apply and you have adult contingent beneficiaries in mind, a transfer on death deed could be the better fit. But remember, these deeds only cover real estate. You'll still need a plan to address other assets like bank accounts, investments, or personal property. The bottom line is, both deeds are powerful tools. These can help you pass your real property to your loved ones without probate. But getting it right is key. If you're in Texas and trying to decide between a transfer on death deed and a ladybird deed, don't leave it to chance. Give us a call to schedule your consultation today. If this video was helpful, subscribe for more tips on estate planning here in Texas.